All right, peace and blessings. It's Tuesday, March the 26th, the year 2019, and we have four new documents in relation to Charles Dyer's bar complaint, where he, I think, issues a grievance against his defense attorney, whose name is Albert J. Hoch, H-O-C-H, Albert J. Hoch, H-O-C-H, Jr., and we're going to read these documents into YouTube, and I might even read Operation Floodlight itself. That's a 41-page document. And this is for people who won't go through the trouble of downloading documents, but they'll turn on a YouTube video while they're cleaning the kitchen or driving down the road, or you can put earphones in while you're mowing the yard. And so if you want to listen to me read Charles Dyer's bar complaints, I don't know if I don't know if I even can. It's so many pages, but we'll just get started and see what happens. But because Operation Floodlight is only 41 pages, I probably could do that. You know, I've read the entire Schaefer-Cox transcripts of the entire trial. It took hundreds of hours to read that into YouTube, and so this should not be all that big a deal. But if I'm going to read it, I might as well turn on the recorder and read it into YouTube, right? So here we go. This first file is called Complaint Sent to Oklahoma Bar Association on Hoch, H-O-C-H. And it starts off with the first page as being a grievance form. It's 54 pages long. Keep in mind we got four files. The first file is 54 pages. It says it's issued to the Oklahoma Bar Association for Charles Allen Dyer. It's a grievance against Albert J. Hoch, Jr. It says, what, if any, amount was paid to the attorney? $24,000 cash, $2,000 goods. It was paid between October 3rd of 2011 and January 19th, 2012. It says, in the event, I'm skipping some questions that simply are not answered, but questions that have an answer I'm reading. So for the full context of everything, you've got to download the file and read it yourself. But I'm just trying to get the highlights in this verbal reading, audio reading. In the event of a disciplinary hearing is held, would you be willing to appear and testify as a witness? And Charles says that he would. Page 2 of the grievance form says names and addresses of witnesses to this grievance. You have Robert Jackson, Jan Dyer. And then it says the nature of grievance to represent the nature of grievance against the attorney. State in full detail. Use separate pieces of paper if necessary. If you employed the attorney, state what you employed him or her to do. Include what the attorney did or did not do. Further information may be requested. So here's how Charles answers that section. I employed Mr. Hoch to represent me on criminal charges that had resulted in a hung jury on the first trial with a different attorney. I was charged with child molestation. After the hung jury, the OSBI performed a forensic exam on my wife's computer and found that her computer was used to do searches about how to get custody of our daughter. Pornographic websites were viewed multiple times. The day before, our daughter had to describe sex acts that were able to be viewed on the site, and my ex-wife used the computer just minutes before one of the times pornography was viewed. Mr. Hoch lied and said he was going to submit this in trial. He did not add Agent Donald Raines to the exhibit list. He did not add the OSBI written report or data disk to the exhibit list. None of this was presented to the jury. After the trial, my appellate attorney, my mom, and I were all unable to get in contact with Hoch for extended periods of time. My appellate attorney was unable to get my evidence until after the initial due date of my appeal, months after sentencing. I wrote a pro se appeal and sent it to my attorney to give him ideas. It was only after he saw my brief that my attorney notified my mother that my evidence box contained no trace of the OSBI report. If I hadn't written the brief, no appeal would have been filed concerning that evidence. It wasn't until after paying Mr. Hoch that he told me he had a dating relationship with someone in the DA's office. Then he lied about presenting the OSBI evidence. Not only did he remove the written report and data disk, he even removed the hard drive that was listed as Exhibit 11 without my knowledge. And then it's signed May the 1st, 2013 by Charles A. Dyer. All right, it goes on to say on another piece of paper, Mr. Hoch lied to me, refused to present critical evidence, and then scrubbed my evidence because of all traces, and then scrubbed my evidence box of all traces of this evidence. Upon further investigation in the last couple of weeks, I was able to locate the hard drive, Exhibit 11. Mr. Hoch, for reasons unknown to me, gave it to my mother. A photo that she took of it is with this complaint. A copy of exhibit list and the OSBI report is with this complaint. I am currently appealing my case for ineffective assistance of counsel. A copy is with this complaint. I found a case where someone had similar difficulties with Mr. Hoch. A copy is with this complaint. Then the next page, there's a picture of a hard drive. It's 80 gigabytes. It's a Western Digital. And it says Defendant's Exhibit 11. And then there's an affidavit to the Oklahoma Bar Association, April the 25th, 2013. Looks like it's an affidavit by Mrs. Dyer. Yes, it is, Mrs. Jan Dyer. So let's read Mrs. Jan Dyer's affidavit. April the 25th, 2013. My son, Charles Dyer, had removed an external hard drive he was trying to locate while incarcerated. He had asked me to see if his hard drive from his computer had been found anywhere by law enforcement. I had been asking Mr. Hoch if he had ever found whether or not the missing hard drive belonging to our son, Charles Dyer, had been recovered. Mr. Hoch said that it had not, as far as he knew, but would ask again. Then on the second day of the trial, April 2012, Mr. Hoch handed me a hard drive at the end of the court day and said they said that this is the only one they have. I took the hard drive home and we discovered that it was not our son's, but a clone of the hard drive of my son's wife, Valerie Dyer's, computer. And I thought was the one he had also had. I put it up and didn't look at it again, as it was not what I was looking for, and knew that the original was in the evidence with the district attorney, and Mr. Hoch had a clone in the evidence. The case resulted in a conviction. A sentencing hearing was held, and a motion for an appeal was filed on June 2012. Our son was determined to be indigent, and an attorney from Oklahoma Indigent Defense was appointed. Mr. Hoch told us that he knew Mr. Jackson, the appointed indigent defense attorney for Charles Dyer, well, and would help him in any way he could with the appeal. I received a call from Mr. Jackson, the Oklahoma indigent defense attorney, in September 2012, stating that he agreed to let the defendant assist in the research and completion of the brief that would be due November 17, 2012. The defendant and myself did a lot of letter writing and research, during which time the defendant sent a copy of an OSBI computer forensic report to Mr. Jackson, who had not yet received the evidence box from Mr. Hoch. Mr. Jackson said Mr. Hoch was still trying to get the evidence together and would get it to him. Okay. Received a call from Mr. Jackson on November the 14th, 2012, stating he still did not have the evidence box and would have to request a 30-day extension for filing of the brief, of which he could request 2. This resulted in a serious delay in the ability to research the case and file a timely brief for the appeal. On November the 16th, 2012, I received a call from Mr. Jackson stating he still did not have the evidence box and had requested and was granted the first 30-day extension. On November the 18th, 2012, received a call from Mr. Jackson stating that he just acquired the evidence box from Mr. Hoch the day after the first filing date of the appeal. During the next month, there were several calls regarding preparation and evidence. Mr. Jackson said it was very difficult to contact Mr. Hoch, and on one call asked if I knew the chain of custody of the OSBI written computer forensic report. I told Mr. Jackson that it had been given to Mr. Hammond, the attorney for the first trial in April 2011, which had resulted in a mistrial. Mr. Hammond had been allowed to withdraw from the case, but it had been generated at the request of the district attorney after the first case, but before Mr. Hammond withdrew, keeping the chain of custody intact to that point. Mr. Jackson contacted Mr. Hammond and acquired an affidavit of his receipt of the report into evidence. The brief was filed by Mr. Jackson with the appellate court on January 17, 2013. At the end of the trial, Mr. Hoch returned evidence to the family from the evidence box, including a calendar, letters from Charles Dyer's wife, and a baby book. During the trial preparation, Mr. Hoch talked frequently about being an attorney in California and working with the cartel. He discussed the fact that he was a sergeant in the U.S. Marine Corps. Charles Dyer was also a sergeant in the Corps. Mr. Hoch made at least 2 trips to Las Vegas, Nevada to help a friend with a big case, and then bragged frequently about being catered to by the big casinos in Las Vegas. Mr. Hammond offered to help Mr. Hoch on his own time with any questions he might have about the case and had put together an informational packet which Mr. Hoch refused to accept. Mr. Hoch told me that he didn't need or want any help from anyone, that he has it covered. During the trial at one of the breaks, Mr. Hoch bragged about being a drinking buddy with the district attorney and knew the judge well, knew how to handle him and not to worry. Mr. Hoch refused to present the evidence which had been presented in the previous trial and called no expert witnesses. The previous trial resulted in a mistrial, and we now had more evidence which he refused to present. When we met with Mr. Hoch in the evening between trial days, he was drinking and said everything was going the way he wanted. Mr. Hoch and I had a verbal agreement as to the fact that he would provide a private investigator, acquire school records, provide expert witnesses, and the trial would probably last at least 1 week. These were never provided, and the trial lasted 2.5 days, at which time Mr. Hoch rested without any consultation or discussion with Charles Dyer, that no further evidence would be provided, and only called family and one friend to stand beside the defendant. During the trial preparation time and after the trial was over, it was extremely difficult to contact Mr. Hoch. At first, he would answer calls, but the closer it got to the trial date and after the trial, it was next to impossible to get him to answer a call or give the answer to a question to his office manager to relate to us. Charles Dyer had a polygraph set up by Mr. Hoch prior to the trial, and it was stopped halfway through. I called the courthouse to see why, and the judge's office said Mr. Hoch would have to tell us. I called Mr. Hoch's office, and this time he did call me back. He said to give him a week or so and he would find out, because he didn't know either. It has now been 5 months and I have not heard from him. On April the 23rd, 2013, I asked Mr. Jackson, Charles Dyer's current attorney, if there was a hard drive clone in the evidence box, and he said he had not seen one and there was not one in it when he received it. I then decided to look at the hard drive clone, which Mr. Hoch had given me during the trial again. As during the trial, I just put it away for safekeeping for later. On the back of the hard drive clone is a blue evidence sticker that says Exhibit 11, with a white sticker with source on it. On reviewing the exhibit list for both trials, the hard drive is listed under Exhibit 11. This is the hard drive which should have been in the evidence box and should have been transferred to Mr. Jackson by Mr. Hoch, contained in the evidence box. Also missing was the OSBI printed computer forensic report and the CD with the OSBI computer forensic report, which had been given to Mr. Hammond by the district attorney at the same time the printed report was given to him. The evidence is a big part of the case, and without the defendant bringing the existence to the attention of Mr. Jackson, it would have been lost forever if the appeal had been filed without it. Jan Dyer. Then on page 8, it says Proposition 1. And I'm going to pause here and pick back up a little bit later. Okay, we're picking back up with this document on page 8, it appears. It says Proposition 1. Mr. Dyer failed to receive the effective assistance of counsel guaranteed by the Sixth Amendment of the United States Constitution and Article 2, Section 20 of the Oklahoma Constitution. Then there's a Section A called Standard of Review. And then there's a Section B called Counsel's Performance was deficient because he failed to call certain witnesses. So that's just a bunch of legal stuff. But you guys can go read that if you want to. Well, you know what? Maybe I should read some of it. The Standard of Review says, claims of ineffective assistance of counsel are evaluated under the two-prong test of Strickland versus Washington, a bunch of numbers. First, it must be determined whether counsel's performance was deficient, whether it was unreasonable under prevailing professional norms, and could not be considered sound strategy. Second, it must be determined whether counsel's deficient performance prejudiced the defense of the case. Prejudice is shown if there is reasonable probability that for the counsel's errors, the outcome of the proceeding would have been different. A reasonable probability is one sufficient to undermine confidence in the trial's outcome. These determinations are made using a de novo standard of review. The second one says counsel's performance was deficient because he failed to call a certain witness. Prior to appellant's 2012 trial, Valerie Dyer had admitted on multiple occasions under oath that she would do or say anything, including committing, this appears important. Prior to appellant's 2012 trial, Valerie Dyer had admitted on multiple occasions under oath that she would do or say anything, including committing perjury, to keep appellant from obtaining custody of the daughter. I'm not going to ever say the name, I'll just refer to the daughter. For example, during the cross-examination of Valerie by defense counsel at the July 2010 preliminary hearing, the following occurred. He, appellant, told you that he was going to try to get custody of his daughter, didn't he? Valerie, yes. That upset you, didn't it? Of course. Valerie, of course. Did you tell Mr. Dyer that you would do anything or say anything to keep him from getting his daughter? Valerie, yeah. Valerie made similar admissions during an April 2011 motion hearing and during the first trial, and then there's references given. Essentially, appellant's theory of defense at the first trial was that Valerie, fearing she would lose custody of the daughter, again, every time it says the initials or the name, I'm just going to say daughter, and angered by appellant's relationship with her one-time best friend, concocted the allegations and then coached the daughter to repeat them. In September of 2011, appellant's original attorney, Mr. Hammond, withdrew from the case and was replaced by Mr. Hoch. Despite the change in counsel, appellant could have reasonably expected his theory of defense to remain unchanged. After all, the first trial had ended in a hung jury, and less than 2 weeks before the third trial began. Mr. Hoch filed a witness list that listed the same witnesses previously listed by Mr. Hammond. Like Mr. Hammond, Mr. Hoch called some of the same witnesses to present appellant's defense to the jury. The witnesses consisted of appellant's sister, Amy, his mother, Jan, his girlfriend, Amanda, and appellant. And then there's references given. However, several witnesses who testified at the first trial were conspicuously absent during the 2012 trial. The absence of these witnesses left the presentation of appellant's theory of defense dismally incomplete. Among the witnesses who testified at the first trial but did not testify at the last trial were Sheriff Deputies Joshua Seeley and Christopher Lemons, Oklahoma State Bureau of Investigations, OSBI, criminalist, Sarah Ferrero and Ashley Sosby, and computer expert Marvin Dutton. In addition, appellant contends that defense counsel should have called OSBI special agent and forensic computer expert Donald Raines. The witnesses would have cast devastating questions about Valerie's credibility regarding the circumstances of the alleged disclosure and reporting of the purported abuse, and would have demonstrated the utter lack of any corroborating physical evidence concerning the accusation that the alleged abuse occurred in Mr. Dyer's home. In addition, the testimony of defense computer expert Dutton and OSBI agent Raines about searches and downloads made on Valerie's computer would have significantly substantiated Mr. Dyer's defense theory that the allegations were concocted by his scorned and vengeful ex-wife. Deputies Seeley and Lemons possessed information which bore directly on Valerie Dyer's credibility. To begin with, Deputy Seeley could have testified, as he did at the first trial, that Valerie reported the allegations on Friday, January the 8th, 2010, references cited. This in itself is no trivial matter because although Valerie has never been able to recall when the alleged disclosure occurred, she has testified that the child returned to her the day before school started. References cited. According to Janet Dyer, Monsalve, and appellant, Valerie picked up daughter on the evening of January 3rd, 2010. References cited. According to Rodney Calhoun, an administrator with the Duncan Public School System, classes did, in fact, resume on Monday, January 4th, 2010. The date that Valerie contacted authorities is important in light of her unyielding insistence that she reported the abuse to the Stevens County Sheriff's Department the day after daughter disclosed the abuse to her. References cited. Had Deputy Seeley testified that Valerie did not report until January the 8th, 2010, the jury would have been forced to conclude that either daughter did not disclose on the... And then there's footnotes 5 and 6, which you guys can read for yourself. Okay, hold on. The daughter did not disclose on the day that she returned from the visit with her father, or Valerie delayed reporting the allegations to the authorities for 5 days. Either scenario is fundamentally at odds with Valerie's testimony as to how the disclosure occurred, and had the jury known this, it would have done much to undermine her credibility. Deputy Seeley could have also testified, as he did during the 2011 trial, that Valerie's January the 8th, 2010 report to the Sheriff's Department included a report of 2 prior accusations of sexual abuse by a daughter against her father. Let me read that again. Deputy Seeley could have also testified, as he did during the 2011 trial, that Valerie's January the 8th, 2010 report to the Sheriff's Department included a report of 2 prior accusations of sexual abuse by a daughter against her father. One when the family lived in California, and the other during the summer of 2009, shortly after the appellant got out of the Marine Corps and returned to Oklahoma. References cited. According to Seeley's probable cause affidavit, Valerie claimed that she confronted appellant because of daughter's prior disclosures. Reference cited. This information would have further undermined Valerie's credibility with respect to her account of the alleged disclosure that occurred following daughter's visit with appellant. Valerie testified that following the visit, daughter was crying more and not acting like herself. References cited. Valerie claimed that she asked the child what was wrong, and the daughter told her that she did not want to talk about it or that she did not want to tell her mother what was wrong. References cited. This caused Valerie to think that maybe she got grounded or got a spanking. References cited. According to Valerie's account, even when the daughter began complaining that her vagina was hurting, Valerie's reaction was to think that perhaps the child drank too much soda or had a urinary tract infection. References cited. In light of Valerie's claims that the daughter had accused appellant of sexually abusing her as recently as the summer of 2009, and given that Valerie found these accusations credible enough to confront appellant about them, it seems incredulous that she would react to the child's demeanor and complaints in the way she described to the jury at the third trial. Deputies Seeley and Lemons were also important defense witnesses because they took various items from appellant's trailer and submitted them to the OSBI for testing. As previously noted, appellant and Monsov went to the Stevens County Sheriff's Office on the afternoon of January 12, 2010. Appellant did so because the email Valerie sent to Monsov on the previous day made him suspect that Valerie had some type of false allegation against him. References cited. Appellant also wanted to help the sheriff's office in enforcing his visitation rights with daughter. References cited. Shortly after he arrived at the sheriff's office, appellant was arrested and placed in jail. References cited. Monsov, who had accompanied appellant to the sheriff's office, testified at the first trial that she remained at the sheriff's office for several hours after appellant's arrest while the Department of Human Services contemplated the removal of Monsov's daughter from her care. References cited. Monsov did not return to the trailer she shared with appellant until deputies executed a search warrant for the premises during the late evening hours of January the 12th, 2010. References cited. The search warrant authorized officers to seize items that could have been worn or used by the victim and that could possibly contain DNA evidence of Charles Dyer. References cited. The officers who had been informed that the abuse had occurred both in the master bedroom and in the living room seized pillows, sheets, quilts, and a comforter. All of the bedding from the bed in the master bedroom. They also took the cushion covers from the furniture in the living area. References cited. At the trial that resulted in appellant's conviction, Monsov testified that she gave officers panties and pajamas belonging to daughter. The garments had not been laundered, and Monsov believed that the daughter had worn the panties from the evening of December the 31st, 2009 to January the 3rd, 2010. References cited. Monsov's account is consistent with the testimony of Deputy Lemons and Seeley at the first trial. Deputy Lemons characterized Monsov as fully cooperative during the search and stated that the pajamas and panties were retrieved from the dirty clothes hamper. References cited. Deputy Seeley also observed Monsov retrieve the pajamas and panties from the hamper. References cited. Although the jury convicted the appellant did not know it, the seized items were submitted to the OSBI where testing was performed by criminalists Sarah Ferrero and Ashley Sosby. Ferrero tested the bedding taken from appellant's bedroom for the presence of blood, semen, and seminal fluid. References cited. Although Ferrero found spermatozoa on a sheet and on the comforter, no seminal fluid or other fluid was found on the pajamas or on the panties worn by the daughter. On January 2nd, 2010, the date she claims she was last abused by the appellant. References cited. Sosby subjected various stains found on the bedding to DNA testing. References cited. The substances matched the known DNA of appellant and Monsov, and in one instance, Monsov's daughter could not be excluded as a possible contributor of a mixed substance stain. References cited. Sosby did not find any DNA which could have originated from the daughter. References cited. Deputy Seeley and Lemons also had information about Valerie's computer, which was valuable to the defense. Sometime after Valerie and the daughter returned to Oklahoma in September of 2008, Appellant sent her a computer. Valerie mentioned this fact in passing during her testimony at the final trial. References cited. During cross-examination, Valerie claimed that many people had access to her computer and she was denied using the computer. She denied using to the computer to view pornography or to conduct various internet searches. References cited. Okay, we're going to pause here and pick up on page 16 in the future. All right, let's continue. Picking up at the end of the last page. During cross-examination, Valerie claimed that many people had access to her computer, and she denied using the computer to view pornography or to conduct various internet searches. Sources cited. What the jury did not know was that several days after she reported daughter's allegations to the sheriff's department, Valerie gave the computer to Deputy Lemons. Sources cited. She did so because the computer had once belonged to appellant, and Valerie claimed that it contained child pornography. Sources cited. In April of 2011, Deputy Seeley transported the computer from the Stevens County Sheriff's Department to Applied World Technology in Duncan, Oklahoma, where Marvin Dutton cloned the computer's hard drive. Sources cited. This was done at the request of David Hammond, who was appellant's defense counsel at the time. Sources cited. During the trial, Dutton testified that he began working with computers in the military in 1962 and had continued to work with computers in various capacities since that time. I'm not going to say sources cited anymore. I mean, if you want to know when sources are cited, you're going to have to look at the actual document. In 1980, Dutton founded Applied World Technology, a company that, among other things, designs and manufactures computer systems. Dutton testified that he cloned or made an exact duplicate of the computer's hard drive. T.R. Marvin Dutton. The clone data indicated that the computer had been used on December the 25th, 2009, 8 days before the alleged disclosure, to conduct internet searches in reference to child abuse and custody of children versus how to gain custody and how to report crimes against children. According to Dutton, there were probably 20 different searches done on December the 25th, 2009, all in reference to the same line of sexual abuse, misconduct of a child, and what's required to report, what's required to file such a case. Dutton also testified that the computer was used to visit various pornographic websites during the end of December 2009 and the first days of January 2010. The jury that convicted Mr. Dyer also did not know that the days after the first trial resulted in a mistrial. The jury that convicted Mr. Dyer also did not know that the days after the first trial resulted in a mistrial. The prosecution requested that the OSBI perform a forensic examination of the computer for any evidence of the possession of child pornography, any electronic communications between Charles Dyer and Valerie Dyer, and an analysis of the internet history from October 2009 through January 2010. Appellant's Exhibit 2. According to Agent Rain's report, the computer did not contain child pornography, as Valerie had told Deputy Lemons. In a finding consistent with Dutton's testimony, Agent Rains found that the computer was used to access internet search engines or websites and search for terms related to parental rights. Agent Rains also found the computer to contain 1,083 graphic image files. There's a footnote on number 7. You can read that when you get a chance. Okay. 1,083 graphic image files which depicted pornography. The images were accessed on 6 different dates beginning on December the 25th, 2009 and ending on January 12th, 2010. The report indicates that 97 pornographic images were downloaded before the daughter made the alleged disclosure, and 438 pornographic images were downloaded on January the 11th, 2010, one day before the daughter was forensically interviewed by Jessica Taylor. C. The failure to present witnesses was prejudicial. Appellant contends that if the above described evidence had been presented to the jury, there is at least a reasonable probability that the outcome of his trial would have been different. Appellant's jury had no concrete evidence concerning when the alleged disclosure was made by the daughter to Valerie or when Valerie reported the allegations to the Stevens County Sheriff's Department. In what is obviously an error, Valerie testified that the disclosure was made around the end of December 2009. On cross-examination, Valerie testified that she did not remember the date of the disclosure. However, during the first trial, Valerie acknowledged that the disclosure was made the day before school started. Given this state of affairs, it was important for the defense to demonstrate to the jury that the daughter's school reconvened on Monday, January 4th, 2010. See Appellant's Exhibit 1. The fact is consistent with Valerie's earlier testimony and the... Let me read footnote 8. Despite Valerie's claim that the daughter did not attend school the week following the disclosure, school records obtained by previous defense counsel indicate that the daughter attended school every day the following week except Friday, January the 8th, 2010. Okay, this fact is consistent with Valerie's earlier testimony and the testimony of Janet Dyer, Monsalve, and Appellant, that the child was returned to Valerie on the evening of January 3rd, 2010. Mr. Dyer's jury should have known that the alleged disclosure occurred on January the 3rd and that Valerie did not report the allegations until January the 8th. The combination of this evidence indicates that Valerie, who claimed that she was faced with a tearful 7-year-old with an obvious vaginal injury, who was reporting sexual abuse against her father for the third time, waited 5 days before she reported the allegations to authorities. Alternatively, the evidence suggests that the daughter did not disclose the abuse on the day that she returned to Valerie's home. The omitted evidence would have rendered Valerie's emotional and tearful account of the daughter's disclosure completely unworthy of belief. Defense counsel's failure to call OSBI criminalist Ferraro and Sosby also was prejudicial. During her forensic interview, the daughter claimed that she was raped and sodomized on Appellant's bed and in the living room of the trailer on January the 2nd, 2010. See State's Exhibit 3. The jury knew that Monsalve gave clothing belonging to the daughter to deputies on the evening of January the 12th, 2010, and that the clothing included panties worn by the daughter from December the 31st, 2009 to January 3rd, 2010. Monsalve also testified that the officers took bedding from the bed in the master bedroom. The jury did not know, however, that subsequent testing of these items failed to reveal any evidence to corroborate the daughter's claims of abuse. Finally, given the appellant's theory of defense was that the daughter made the allegations because she was coached to do so by Valerie, defense counsel's failure to inform the jury about the activity found on Valerie's computer was unquestionably prejudicial. Had the jury known that in the days before the alleged disclosure was made, Valerie's computer was used to research what's required to file a sexual abuse case, appellant's theory of defense would have been made more believable. Even more powerful would have been testimony from Agent Raines indicating that an extensive amount of pornography was downloaded on Valerie's computer the day before the daughter was forensically interviewed. This evidence would have given force to appellant's claim that the daughter had been coached. There can be no reasonable strategic reason for the failure to call these witnesses. The deputies, the criminalist, and Marvin Dutton are each listed on the witnesses list filed by Mr. Hoch on April the 3rd, 2012, less than 2 weeks before trial. Despite defense counsel's professed intention to call the witnesses, he did not do so, and the result devastated the defense of Mr. Dyer's case. As to Agent Raines, defense counsel, defense counsel knew or should have known that his forensic examination of Valerie's computer uncovered information that was vital to Mr. Dyer's defense. Conclusion. Omissions that cannot be explained convincingly as a result from a sound trial strategy, but instead arose from oversight, carelessness, ineptitude. Hold on just one second. I've got a thing I've got to deal with right now. Hold on. Okay, sorry. Or laziness may fall below the constitutional minimum standard of effectiveness. Rosario versus Urkel. Other cases are cited. Appellant contends that this is such a case. Accordingly, the court should find that counsel's failure to call the witnesses identified in this proposition constitutes deficient performance. The court should also find that Mr. Dyer was prejudiced by his counsel's deficiencies. The defense advanced during the first trial included the testimony of the witnesses identified in this proposition, with the exception of Agent Raines. The trial did not end in Mr. Dyer's conviction. Mr. Dyer's conviction in a trial in which the testimony of the above described witnesses was excluded should lead this court to conclude that the appellant has sufficiently demonstrated a reasonable probability that, but for the counsel's errors, the outcome of his trial would have been different. Accordingly, this court should reverse appellant's conviction and remand this case to the district court for a new trial. In the alternative, the court should provide Mr. Dyer with the opportunity to demonstrate that, but for the deficiencies of his trial counsel, the result of his trial would have been different by remanding the case to the district court for an evidentiary hearing. See application of an evidentiary hearing on the Sixth Amendment claims filed contemporaneously with this brief. All right, page 22 is a list, appears. Item number 28 is Sarah Ferrero, Oklahoma State Bureau of Investigation. 29 is Jim Taylor with Colt Defense. 30 is Abigail Wilson, Department of Human Services. Let me read this again. This appears to be some sort of witness list. 28, Sarah Ferrero, Oklahoma State Bureau of Investigations. That's OSBI. Who may be called to testify about the facts related to the stains and samples taken and the testing of DNA evidence. 29, Jim Taylor with Colt Defense, P.O. Box 118, will testify about the authenticity of the grenade launcher. Abigail Wilson will testify about the investigation of sexual abuse allegations against the daughter and IC. 31, Justin McCowan will testify to the character of the defendant and to the facts related to this matter. 32, Deidre Hampton will testify to the fact that she is a former neighbor of Valerie Dyer and that witnessed numerous men entering and leaving Valerie Dyer's residence during the time period when the alleged sexual assault had occurred. 33, Carl Ray Wiley, father of Valerie Dyer, will testify to the fact that he attempted to assault the defendant and Amanda Monsov by pointing a loaded firearm at them on or about the 4th day of May 2011, will testify about Valerie Dyer and her family's hatred toward the defendant at the time the allegations were made. 34, Dan Fletcher, Duncan police officer, will testify regarding his investigation of a complaint filed by Valerie Dyer on or about May 24th, wherein she claimed the defendant was in the vicinity of her workplace and that these actions violated a protective order. 35, custodian of records, will testify about the verification of school attendance records of daughter between January 3rd, will testify regarding the date students were out of school during the Christmas break. 36, Connie Elam, Stevens County Court Clerk, will testify the authenticity of certified court records of James Hikia. 37, Nathan Cario, will testify regarding the defendant's character. 38, Justin Deal, will testify regarding his recent encounters with Valerie Dyer, to his status as the father of a child she is pregnant with, and her statements regarding what she would do to prevent him from seeing the child and its relation to the present case. 39. Charles Dyer, defendant. Mr. Dyer will testify regarding the allegations against him. He will also testify regarding his relationship with Valerie Dyer and her character and credibility. Exhibit list. 1. Recorded phone conversations between Charles Dyer, Amanda Monsov, and other family members from the Stevens County Jail. 2. Recorded conversation between Charles Dyer and Valerie Dyer. 3. Recorded conversation with Charles Dyer and John Davis. John Davis is the suspected FBI informant who handed him what he thought was a 37mm grenade launcher, but it was a 40mm. 4. Facebook message from Valerie Dyer to Amanda Monsov, dated January 11, 2010, and Facebook message posted by Valerie Dyer, dated December the 14th, 2009. 5. Certificate of release or discharge from active duty. 6. Medical report by Preston Waters, dated January 13, 2010. 7. Copy of affidavits from search warrants and search warrants return. 8. CD of the interview taken at Mary Abbott's house with the minor child. 9. Oklahoma Statute Bureau of Investigation Criminalities Examination Report regarding analysis of the DNA prepared by Ashley Sosby and report prepared by Sarah Ferraro. 10. Report to the District Attorney from Oklahoma Department of Human Services order records pursuant to the order authorizing disclosure of records. 11. Hard drive of the computer from Valerie Dyer. Description of the pornography material and searches. 12. Pictures of the M203 grenade launcher. 13. Criminal felony conviction records of Eric McQuiston. 14. Judgment of acquittal in federal court case. 15. Defendant's motion in limine filed in the federal court case to exclude evidence that the grenade launcher was stolen. 16. Consent to search documents signed by Amanda Monsov. 17. Divorce pleadings, Dyer versus Dyer. 18. Protective order, wherein Valerie Dyer obtained protective order against the defendant. 19. Criminal records of James Hakia. He's like another guy that was part of Valerie's family, Valerie Dyer's uncle, as related to the sex crime conviction upon a family member, to include judgment and sentence, application to revoke judgment and sentence, and documents reflecting James Hakia's residence or where he resides. 20. Photographs of daughter and IC taken during the Christmas break at the defendant's home. 21. Tape recordings of conversation between Valerie Dyer and defendant, wherein Valerie Dyer called the defendant on the 30th day of June 2011. In said conversation, Valerie Dyer admits she made a mistake and filed a false complaint against the defendant, alleging he violated the protective order. The discussion includes issues related to the case, the hatred between the parties, and Valerie Dyer's hatred towards Amanda Monsov. The reason that's important to get Valerie Dyer's hatred about Amanda on record is I believe she testified to the contrary. 22. Criminal records to include but not limited to the information sheet and officer's affidavit relative to the arrest of Carl Ray Wiley, wherein he was charged after pointing a firearm at the defendant and Amanda Monsov. 23. Calendar of the months of December 2009 and January 2010. 24. School records of daughter between the dates of January 3rd through January the 8th of 2010, said records evidencing the attended days of school by daughter during that period. 25. Calendar for December 2009. 26. Calendar for January 2010. 27. Chart of events. 28. Transcript of the previous trial in this matter to include all witness testimony. 29. Baby book of daughter, including but not limited to family photographs within the book. Okay, we're going to jump down to page 26 of 54. This appears to be a notification of witness and exhibit list. You've got the defendant. Well, I'm just going to read randomly from this legal document. It says the defendant reserves the right to call any witness and or introduce any document or other exhibit previously identified to the state of Oklahoma through notifications and amended notifications. Jan Dyer, Amanda Monsov, defendant's sister Amy, Christopher Lemons, Lawson Guthrie, Valerie Dyer, daughter, Jean Poole, Sergeant Burjoyce, John Seeley, Marvin Dutton. And then here is a Oklahoma State Bureau of Investigation's Computer Crimes Unit Computer Forensic Examination Report. Examination report date July 29, 2011. Summary of request. Wow. Wow. The reason I'm saying wow is now that I'm into the OSBI report, there are entire pages that are blacked out, and I don't know why. That's weird. Yeah, pages 29 is completely blacked out. Page 30 is completely blacked out. I don't know. I thought it was going to like show me the actual document, but then it blacked it out. Anyway, it goes on to say, I'm on page 31 now. Password was required to log on using the profile. The registry files associated with this profile identified a total of 638 logons, recorded a last logon of January 12, 2010 at 23:24, and recorded the last password change of January 12, 2010 at 0013. Instant messenger applications. Examination of the exact copy of HD1 revealed a total of 50 files of potential evidentiary value which were related to use of instant messenger or chat applications. 42 of the files were database files associated with the use of application Skype, which was a program which was used to communicate between computers with video, audio, text-based chat, and messaging. The 42 files were all associated with the use of the text-based chat or messaging feature of the Skype application, appeared to be in the conversation between Charles Dyer and Valerie Dyer. Alright, so let's continue. It says the 42 files were all associated with the use of a text-based chat or messaging feature of the Skype application and appeared to be conversations between Charles Dyer and Valerie Dyer, the mother of the daughter, the mother and the wife of Charles Dyer. Okay. The remaining 8 instant messenger or chat-related files of potential evidentiary value were associated with the use of Yahoo Instant Messenger application and appeared to be conversations between Valerie Dyer and either Charles Dyer or 5 other unknown identities or individuals. Click here to view the Yahoo Instant Messenger conversations report. Graphics files. Examination of the exact copy of the HD1 hard drive revealed a total of 1,083 graphic image files which depicted pornography. Of the 1,083 files, 1,079 were found stored in the temporary internet files cache of hard drive 1. 4 were found to be thumbnail images which were stored within the thumbs database, thumbs.db database files. Analysis of the time and date attributes of these images reveal all of these images were created and or accessed from the internet on 6 different dates. See the table below for additional information. So you have December 25th, 2009, 13 images. December 26th, 2009, 2 images. December 31st, 2009, 82 images. January the 5th, 2011, 1 image. January the 11th, 2011, 17 images. January the 11th, 2011, 1 image. January the 11th, 2011, 210 images. January 11th, 2011, 210 images again. And then January 12th, 2011, 543 images. All of the images which depicted pornography appeared to be associated with the internet website redtube.com, which was an adult pornography website. None of the pornography images were stored in a user-created folders. None of the files would have been accessible to a computer user who is not familiar with the storage location of temporary internet cache and how to browse to and view files stored within the temporary cache locations. During the examination of the exact copy of HD1, Rains utilized the data carving function and forensic toolkit to search the unallocated disk space of HD1 for all graphic image files larger than 2 kilobytes. Examination of all graphic image files during the examination of the exact copy of HD1 did not reveal any images which depicted child pornography, child erotica, or any other or additional graphic image files of evidentiary value. Desktop wallpaper. The desktop wallpapers of HD1 were identified as graphic image files which were of no evidentiary value. Video and multimedia files. Examination of the exact copy of HD1 did not reveal any video or multimedia files of evidentiary value. Recycle bin analysis. Examination and analysis of the recycle bin and its associated index files found on HD1 reveal no files or data of evidentiary value. Examination of the resident client and internet-based email found during the examination of all data on the exact copy of HD1 revealed no email messages or email-related files or data of evidentiary value. Internet history. The examination and analysis of the internet history and its associated cache database and index files found on HD1 revealed numerous files, data, and records of evidentiary value, which were associated with the use of the Internet Explorer web browser application. Internet history related to pornography websites. The examination and analysis of the internet history and its associated cache, database, and index files found on HD1 revealed a total of 4 database files of potentially evidentiary value, which recorded entries associated with the use of the Internet Explorer web browser to access internet pornography website, redtube.com. The examination and analysis of the internet history and its associated cache, database, and index files found on HD1 revealed a total of 755 index entries of potential evidentiary value, which recorded information associated with the use of the Internet Explorer web browser to access the internet pornography website redtube.com. Click here to view HD1 Internet History Index entries. Let me say that before, when I was reading this OSBI report, I mentioned there was a couple of pages that were blacked out. That was only because I was using an iPad. For some reason it wouldn't show those pages. I don't know why, but it does show those pages on a Windows computer, but those pages weren't anything significant, so I did not go back and read them. Internet history related to searches and search engines. The examination and analysis of the internet history and its associated cache, database, and index files found on HD1 reveal a total of 3 database files of potential evidentiary value, which recorded entries associated with the use of the Internet Explorer web browser to access the internet search engine or website Bing.com. The examination and analysis of the internet history and associated cache, database, and index files found revealed a total of 44 index entries, Bing.com. Internet history related to parental rights. The examination and analysis of the internet history and its associated cache on HD1, 9 stored web pages return results from search engine to search for the term Oklahoma parental rights. The examination and analysis of internet history and its associated cache, Bing.com. Oh, Information Gateway website. U.S. Department of Health and Human Services. Forget what I said about Bing. U.S. Department of Health and Human Services Child Welfare Information Gateway website to search for the term Getting Parental Rights Back. The examination and analysis of the internet history and its associated cache files found on HD1. Visits to internet websites. Childwelfare.gov. Internet history related to the name Amanda Monsov. So she went to myspace.com and searched for the term Amanda Monsov. The examination and analysis of internet history. The examination and analysis of internet history and associated database. Okay, it's just looks like a lot of data, but I don't see anything that is that's worth repeating in this audio. A lot of information here. Further examination of the files and folders stored on the hard drive revealed there were a total of 10 files, which had modified date and time attributes April the 6th, 2011. 9 files which had modified date and time attributes, with an exception. Further examination of files and folders. Okay, 12 files last created date attribute any other file on January 12th, 2010. Examination summary. The examination of hard drive revealed the Windows XP registry files recorded a last logon date and time of January 12, 2010, 23:24, and that the Charles Dyer profile password was changed on January 12, 2010 at 0013. The examination of HD1 did not reveal any graphic, image files, or video of multimedia files which depicted suspected child pornography or child erotica. The examination of HD1 did reveal the presence of adult pornography, which was all associated with the Internet Explorer web browser to access the internet site redtube.com, or on 9 different instances over 6 different days between December 25th, 2009 and January 12th, 2010. The examination of HD1 revealed a total of 50 chat or instant messaging related files, none of which appear to contain any specific information pertaining to the sexual abuse of daughter. The examination of HD revealed evidence that the Internet Explorer browser was used to access Internet search engines or website search for terms related to parental rights. Analysis of the modified access and created database December 25th, 2009, January 12th, 2010, which corresponds exactly with the dates and times the Internet Explorer browser was used to access the pornography website redtube.com. The examination of HD1 revealed evidence the Internet Explorer browser was used to access the internet website myspace.com and use search functionality of that website to search for the term Amanda Monsoff. January 11th, 2011 at 2023. The examination of HD1 revealed 17 files which were modified, accessed, or created April 2011. The latest modified access created, the HD1 was made available. Photographs of evidence. On July 15, 2011, Raines took a total of 25 digital photographs of Computer 1 and HD1 during the examination process. Click here to view the photographs of all items of evidence. All evidence was retained by the requester and no further examination was requested or required. This request has been completed. Examination of HD1 did reveal the presence of adult pornography, which was associated with the examination. Keep in mind that all of this pornography was during the time that Valerie had possession of the computer, not Charles. Photographs of evidence, yeah. Okay, yes. Approved by the Oklahoma Bar Board of Governors. Definition: professionalism. Professionalism for lawyers and judges requires honesty, integrity, competence, civility, and public service. There's a preamble. It looks like there's some sort of lawyer's responsibility to the public. I'm not going to read all this. Lawyer's responsibility to clients. Lawyer's responsibility to other lawyers. Discovery. There's like sections about discovery. Depositions. Document request. Interrogations and request for admissions. Scheduling. Continuances and extensions of time. Motion practice, non-party witnesses, privacy, default judgment, social relationships with judicial officers, court-appointed experts, administrative agency hearing officers, and agency board members, negotiation of business transactions, lawyers' responsibility to the courts and administrative agencies, writings submitted to the court or tribunal, ex parte communications with the court. There's a lot of information here, and I'm simply just reading you the highlights. Judges' responsibility to litigants and lawyers. Judges' responsibility to each other. All right. So that's the end of the document, which has the title. Hold on. Come on, Rudy. Complaint sent to Oklahoma Bar Association on Hoch. It's 54 pages, and that's the end of the first document, but keep in mind there's a total of 4 documents, so this is just the first of 4.